Now. Today is the 274th Friday group meeting. The topic is a man of honor, Sir B.N. Rao, Benegalla Nursing Rao, born on 26th February 1887, died 30th November 1953 in Switzerland, and was an Indian civil servant, jurist, diplomat, statesman, known for his role as the constitutional advisor to the Constituent Assembly of India. Now, today's speaker is T.Raja, Senior Advocate, a former Acting Chief Justice of Madras High Court. He is kind enough to address on this topic. Rajaji, please, now you can initiate your this very.
Good afternoon to all of you. Esteemed former Chief Justice of Jharkhand High Court, Justice Karpuranayan, my dear friend, Mr. G.Seshagiri Rao, lifeline of T.Raja Group, backbone of T.Raja Group, and more than that, he is a pillar of legal studies, continuously rendering legal education to the legal fraternity. And this is also part of this. Therefore, the T.Raja Group has become part of these legal studies. I must also thank Mr. Rahul Sharma for having given so much of assistance while preparing this speech on the small topic. I was just in fact discussing with Mr. Seshagiri Rao. In fact, he was asking me whether you have any materials, literature. And then I said, of course, I do not have sufficient materials. And then he has profusely helped me after talking to one of the staffs in library, Judge's library, and then he has also made a request to you to give me a book. I went through the book. I am extremely thankful to you for having given me timely assistance. Members of the board, ladies and gentlemen, today we are going to discuss about on the topic a man of honor, Sir B.N. Rao. Why we are going to discuss about a different individual today? I must tell you, look at the entire universe. Alexander the Great became one of the biggest conquerors in the world. He was born 500 years before the Christ was born. But today we are remembering him as unbeaten king. He has conquered 3/4 of the nation in those days, 3/4 of the world. Why? Because he emerged as one of the topmost warrior. Because he was inspired by one of the icon. He was an icon. He was one of the heroes in the Trojan War, Achilles. And then if you see, after Alexander the Great, Julius Caesar, he was inspired by Alexander the Great. And if you just go on like this, go to US, you can remember so many people. The first president of US, George Washington, he fought for America's freedom against the British rule. Ultimately got freedom under his command. And then he was the president of the US, the United States of America, for 2 terms. But when we compare the Washington with other people, we always remember Abraham Lincoln because he has dedicated his life, supreme life, for a particular cause. Because he worked for the equality. He wanted to bring both black and white as equal on one platform. Therefore, we remember Abraham Lincoln. If we come back to India, we have seen in the Indian freedom movement, Mahatma Gandhi ji. Mahatma Gandhi ji, we call him as the father of nation. Similarly, we call Dr. Ambedkar as the father of Indian Constitution. We have many people. We can't forget C.R. Das, Deshmukh, Subhash Chandra Bose, first Prime Minister of India. And if you go down to south, we have Babu Chidambaram. They have given their supreme life for the nation. We are inspired by these people, therefore we thought we must also think about a towering personality like Sir B.N. Rao. Who is this great Sir B.N. Rao? Today we are going to talk about the former President of United Nations Security Council in the year 1950. Today we may not be in a position to go and occupy any seat over there because in 1950, kindly remember, an Indian emerged to the topmost position in the world, a President of the United Nations Security Council, 1950. Not only that, he emerged as one of the towering judges of the International Court of Justice. Not only that, he also passed the toughest examination, ICS, in 1909. We are going to talk about it. He was serving as a district judge in Bengal, and then he was appointed as High Court judge in Bengal. We are going to discuss about it. Not only that, he was the man helping to draft the Government of India Act 1935. And he was the man helping the Burma to draft the Burma's constitution. Such a celebrity we are going to remember today. As Mr. Seshagiri Rao has mentioned, Mr. Sir B.N. Rao was born on 26 February 1887 in Mangalore, in Karnataka. He studied in one of the small schools, Canara High School in Mangalore, and then he graduated from Madras Presidency. He just outshined everybody. He became topmost number one in the entire Madras Presidency in English, in physics, in Sanskrit in the year 1905. And then in the year next year, 1906, he also got the first class in mathematics. Since he got a special scholarship, he was chosen to be a student of Trinity College in Cambridge, and then he went over there, enjoying the scholarship given by the British government. There he took the law as a subject and come up colorfully. In the meanwhile, he has also passed the ICS examination, the toughest examination. When he returned to India, British India, in the year 1909, the government thought of using him to the great election. Therefore, they put him in Bengal as one of the executives. He did his work perfectly, and then that has satisfied the authorities over there in British India, and then they asked him to work as a district judge in East Bengal. He came out successfully, disposed of matters so quickly, understood the matters so quickly in comparison with the other judges. When other judge who was having 10 years standing was able to not dispose of the matter, 10 matters, he was to dispose of 100 matters. So seeing his intelligence, they thought that this man should be taken care of by the Governor General in Council. They posted him as a Secretary of State in the Governor General office. And then they requested him to work in the Reforms office. He worked. You see, wherever he went, he excelled everybody, he surpassed everybody. And then after he was serving in the district judiciary, the Chief Justice of the Federal Court there recommended his candidature to be appointed, elevated as a High Court judge. Again, he became the High Court judge of Calcutta. 3-4 years he was serving. Then thereafter, they requested him to come and work again in the Reforms office. Fortunately, what happened? He was to reach the age of superannuation in the year 1944. Of course, in the year 1938, he was given the knighthood by the British government. And then finally, in the year 1944, he demitted his office as a government servant. That is not the end of his career. Look at the distinguishing career of Sir B.N. After he demitted, he reached the age of superannuation. 2 important assignments came to him. The then government requested him to be a permanent judge of the Calcutta High Court. He declined. He said, I prefer to work in the Reforms office, in the government Reforms office. Then he was chosen as the Prime Minister of Jammu Kashmir. Look at it. 1944, he became the Prime Minister of Jammu Kashmir. He was working there for almost 1.5 years. During his tenure, you just see his brilliance and see how he is different from other people. We have to inspire a lot from B.N. Rao. This is the point I am just going to give you as a message today. We all people, we have seen ordinary people. When a Prime Minister comes, we always go and then we work as a yes man. Whatever he says, yes. Without even understanding, without even appreciating, without even knowing what would be the consequence of this act. But within 1.5 years, he said, I am just quitting, I am resigning from the post of Prime Ministership because I do not want to see you. He wrote a letter saying that the terms and conditions between the Maharaja, Hari Singh and myself has emerged as one. I do not want to look at his face. He has written, he has put it in his writing. I would like to bring to your notice the quotation. He said, yes. When Rao retired from service in the year 1944 and was then appointed as the Prime Minister of the princely state of Jammu and Kashmir, he resigned from his position in the year 1945. Following differences with the 10th Maharaja of Kashmir, Hari Singh, writing in his resignation letter that, quote, I have been conscious for some time that we do not see eye to eye on certain fundamental matters of external and internal policy, and that leads, as it must lead, to disagreement in many a detail. I have never questioned and I do not now question the position that in all these matters, Your Highness' decision must be final. The Prime Minister must either accept it or resign. Therefore, I am resigning. I quote. Unquote. Following his resignation as the Prime Minister of Kashmir, Rao was asked to serve in a temporary capacity in the Reforms Office, the Government of India. Again, he did so. And then thereafter, he was offered once again the position of a permanent judge in the Calcutta High Court, but he preferred to stay in the Reforms Office and work on constitutional and federal issues. And thereafter, in the year 1946, the government thought that a constituent assembly should be created. Why? In the year 1934, a similar personality like Sir B.N. emerged from the same Bengal. M.N. Roy, one of the greatest personalities in the world, in India, whom we cannot forget. This M.N. Roy has advocated to the Indian leaders who were all very busy in the Indian freedom movement. He said, and he was a communist leader, he was a very close friend of Vladimir Lenin, and his writings were appreciated by Lenin. He has suggested to the leaders of the freedom fighters in those days, stating that India should have Constituent Assembly in the year 1934. If you see Article 3 of the Indian Constitution, it says that the Parliament may increase the boundaries of the state, decrease the boundaries of the state, alter the boundaries of the state, alter the name of the state. But no provision in the Constitution says that you can give away the land to any other nation. You cannot divide or you cannot partition. Therefore, anticipating that some problem would come, M.N. Roy in the year 1934 has advocated very seriously, requesting every leaders of the freedom fighters that the India should have the Constituent Assembly. Noticing that these people are having something in their mind, 1937, Burma was taken away from India. I was just discussing with Mr. Rahul Sharma yesterday. Burma was considered in those days, even today also, one of the fertile land, gold mine. In those days, people from India used to go to part of India, that is Burma. And when they come back, they become super rich. A poverty-stricken man, a man doesn't have anything. If he goes there, when he returns, he will come back as a super rich. That was the place, even today it is considered as one of the fertile land. That land was taken away and was given independence by the British ruler before the Constituent Assembly was established. Imagine in the year 1937, Burma was taken up. After 10 years, India was partitioned into two nations, Pakistan and India. And then look at one another, very interesting aspect that in the year 1971, when there was a war between, there was a Cold War, India intervened and then the Bangladesh was created. In the year 1950, Indian government allowed Tibet to become de facto independent nation. You know why? For three reasons. They said the Tibetans are having a different language. The culture, their usage are completely different. Language is different, usage and their food habit is different. Therefore, they can lead their life differently. That cannot be the good reasons. But within a year, China has completely captured Tibet and made it as a part of China. You can imagine. Had we had Constitution of India in the year 1935, before 1937, Burma would have been with India. Pakistan would not have gone away. Bangladesh would not have gone away from India. Tibet would not have gone away from India. Today, in the world map, in the world geography, India would be one of the superpowers. Like, I'm not saying next to US or next to Russia, next to China. We would be on par with US, we would be on par with Russia, we would be on par with China. Nobody would be in a position to throw any challenge to us. This is because we didn't have we have not realized the statement made by M.N. Roy to have a Constituent Assembly. So anticipating that these fragments have taken place. Forget about that. When we forget about all these things, and when we come to Mr. B.N. Rao, this B.N. Rao was asked to be an advisor. He was appointed as a constitutional advisor even before the drafting committee was appointed, constituted. Please remember that. 1946, the Constituent Assembly was formed. After forming the Constituent Assembly, they thought that India should have an independent constitution. They are going to give independence, and immediately after independence, we must have our own law. So therefore, they appointed Sir B.N. Rao as a constitutional advisor in the year 1946. Immediately after he was appointed as a constitutional advisor, he was advised to go to different places, collect the materials, literatures. Not only that, he was also advised to consult personally the authorities, judges, and the politicians all over the world. So therefore, he went from India to US, Ireland, UK, Canada, and all other places, collected materials, met individually all the people over there, whosoever is going to be extremely useful for him to present a draft constitution. Please appreciate that. He went and met one of the very towering personalities in US Supreme Court, Felix Frankfurter. He was in those days considered as B.R. Krishna in India. So he had chosen that gentleman, he met him. Look at how people have taken so much of effort in legislating, in making our Indian constitution. Today we are living on that. It is not just like that. A man just sitting in the library 2 or library 1 was called upon to draft the constitution. Extraordinarily a brilliant man was chosen to be constitutional advisor. As I mentioned to you, a man he has not left any post untouched. He has not left any assignment untouched. Everywhere he has got rich exposures, rich experiences. This gentleman was taken up. When he was appointed, look at the caliber, look at the gratitude of this gentleman. He said, when he was appointed, you can appoint me as a constitutional advisor, but only on one condition, that I must not be paid remuneration, but only I must be paid with the honorarium. And then he was appointed. He went to US and met Justice Felix Frankfurter. After discussing with him, he said, Mr. Rao, your nation has not even got independence. You have not even made your constitution. You are going to be a newly born child. However, in United States, we have the due process of law as a part of our system, part of the constitution. So therefore, please do not go for accepting or including this class due process of law in your constitution. Rather, prefer to have the procedure established by law as a part of your principle. He has explained very clearly why you should not go to adopt or include the class, namely the due process of law. He said, as you are going to become only independent, you are going to have your own constitution. You are only a poverty, stricken country. You may have to do social legislations favoring some people, poor people, poorest peoples. Different laws are required. For example, just think about the reservation class. When you say reservation class, in a professional college like engineering college and medical colleges, we have different parameters. For FC, you should have first class. For BC, you should have 50 marks. For other people, SC, ST, if you have minimum 40 marks, then you can get admission. But this is not acceptable. But in those days they said, you have to cover up, you cannot give equality to all people, you cannot treat everybody equal. Therefore, you may have to legislate, make some social legislation. So if you go for the due process of law, then the due process of law will ask you, the laws should be not only, the procedure to be adopted is not only going to be fair, reasonable and just, even the content of the act also should be fair, reasonable and just. Therefore, please do not adopt the due process of law, was the advice given by the great man, Felix Frankfurter. You take the case of the Indian Constitution. When we got independence on 15th August 1947, within 2 weeks, on 29th August 1947, the drafting committee was constituted, consisting the chairman, Dr. Ambedkar, and the 6 other members, T.T. Krishnamachari, Aladi Krishnasamy, and then several other people. When the drafting committee was constituted, Mr. B.N. Rao has completed his exercise. He has handed over the draft constitution. He has indicated, sir, you may go to either the procedure established by law or the due process of law. But people may say that you can go to adopt or include the class called the due process of law. Please do not go to the class, namely the due process of law. And he has explained all these things. With respect, I would say, Dr. Ambedkar did not accept that. But before accepting that, I must also read a quotation from Dr. Ambedkar made about Sir B.N. Rao. He said, when the entire constitution work was completed, Dr. Ambedkar presented the constitution on 25th November 1949, publicly acknowledging Sir B.N. Rao's contribution, stating that, I quote, the credit that is given to me does not really belong to me. It belongs partly to Sir B.N. Rao, the constitutional advisor to the Constituent Assembly, who prepared a rough draft of the constitution for the consideration of the drafting committee. So Dr. Ambedkar has openly acknowledged the contributions made by the constitutional advisor Sir B.N. Rao, saying that you all people are all appreciating that I have single-handedly drafted the constitution painfully. No, I can accept part of the credit, but part of the credit should go to the constitutional advisor B.N. Rao. He himself has admitted it. Look at the complications and look at the real practical problem faced by the makers of the constitution. When the constitution was brought into action, brought into implementation, with effect from 1950, 26 January 1950, the entire constitution came into operation. People, we became independent, we became a republic. So we got independent and subsequently we became a republic. After we became a republic, we were not able to alleviate the poverty faced by all people. In India, you all people were aware of the fact that 565 princely states were there, Jamins. If you go to Bihar, Orissa, Tamil Nadu, each Jamin will be having thousands of acres, 2,000 of acres. And in Tamil Nadu, we have several, group of Jamindars. So one Jamindar will not be able to locate his own farmhouse, his own estate. So the government thought, the first government thought that we take over the Jamindar system, abolish the Jamindar system. For example, if I am having 10,000 acres of land, this 10,000 acres of land, I may not be able to cultivate. So my laborers will be working there only for 200 acres, 300 acres. So the rest of the acres lands would be lying barren. So the government thought, after undertaking a huge study, we will abolish the system we will distribute the excess land to the poor people. The abolition of the Jamindari system came in 1951. 3 high courts were approached by the Jamindars. The Bihar government, the Patna High Court, and then Allahabad High Court, Madhya Pradesh High Court. Madhya Pradesh High Court and the Allahabad High Court have upheld the validity of the abolition of the Jamindar system, the Reforms Act. But the Patna High Court has struck down, saying that right to hold the property is fundamental right, but you are taking away the property, therefore this is against the constitution. Now you can imagine the advice given by Justice Felix to our B.N. Rao was absolutely correct now. He said, so you are going to enter a new era in which even you may have to prepare and adopt, you may have to legislate some social legislation. These social legislations are going to have a different yardsticks. Therefore, if you are going for adopting what you call this due process of law, then you may not be able to save the law, in which even some reforms may not be able to take place. As I mentioned to you, if you get admission, if you are going to get admission in professional colleges, engineering colleges, and medical colleges, you can't fix 60 marks to all people. A son of a High Court judge, a son of a Supreme Court judge, a son of President of India, a son of Vice President of India. The infrastructures given to their children will be something different. But a sweeper working in a village, he may not have seen computer, he may not have seen even a car or even cycle. So how are you going to just equate all these people? Therefore, we said a man who is hailing from village, a Dobi, son of a Dobi, son of a barber, if he possesses minimum 40 marks, he will be able to get admission in medical college, engineering college. But at the same time, if you are a son of an IAS officer, if you are a son of a President of India or High Court judge, Supreme Court judge, you must have more than first class, 60% mark. Nothing wrong in that. If you apply that principle, then you cannot escape from the scrutiny of the test of the due process of law. Therefore, they anticipated all these problems and then advised accordingly. In India, if you are adopting the due process of law, then you may not be able to do major reforms. On this basis, Mr. B.N. came and then advised the committee, the drafting committee, let us go to adopt what we call the procedure established by law as one of the theory that should build the safety walls of the Constitution of India. Then what happened? In fact, I must read out some of the discussions that has taken place in the Parliament. The people have taken up this subject, why the due process of law should not be taken and why the procedure established by law should be ignored. Several days the discussions were taking place. I would just read only the relevant portion of the discussions that has taken place in the Parliament. Finally, even Dr. Ambedkar also wanted to adopt the theory called the due process theory. And finally, what happened, when there was equal opposition, the matter was given to voting. And then the Munshi was one side and the Alladi Krishnasamy Iyer on the other side. Alladi Krishnasamy Iyer, he was advocating only for implementing, including what he called the practice established by law should be the principle we should include in the Constitution. On the other hand, the Munshi said, no, the procedure established by law is completely useless. We'll go for the due process of law. That was the advocate, that was the argument advanced by Mr. Munshi. Finally, what happened? There was equal, voting. Then he went for voting. People chose to go for accepting what he called the procedure established by law should be accepted. Ultimately, with too much of concern, Dr. Ambedkar has accepted it. He said that I am unable, I am helpless. So let us adopt the procedure established by law as the theory that should always govern the basic principles of the Constitution of India. This is how the procedure established by law has come into existence. If you see Article 21 of the Indian Constitution, it says that no person shall be deprived of his life, personal liberty, except in accordance with the procedure established by law. In fact, this original draft was made by the Dr. Ambedkar. He says no person shall be deprived of his life, personal liberty or property except in the due process of law. That was the draft made by Dr. Ambedkar. But this has been completely changed. And I would read only a small portion of the discussion that has taken place in Parliament. The debate over the due process clause extended over several days in the Constituent Assembly in December 1948. The debate culminated on December 13th when Dr. Ambedkar, in an important and lucid speech, summed up the arguments pro and con and called for a vote. And ultimately, the voting took place. Everybody said that only the procedure established law should be followed, and finally they taken up. Now the point is, why we should go for adopting the doctrine or the principles of the procedure established by law, then the due process of law. You take the case of Constitution has come into existence. It has come into force from 26 January 1950. I have mentioned to you the Land Reforms Act. Two high courts have upheld the validity, and one of the high courts, Patna High Court, has said disallowed. Finally, the Indian Constitution had to sit for amending the Constitution. How they amended the Constitution? They said, see, the part 3 of the Constitution deals with the fundamental rights. Article 14, 15, 16, 19, 21. So 19 says that all citizens shall have the right to freedom of speech and expression. 19(1)(b) says all citizens shall have the right to form an association, assemble peacefully and without arms. All citizens shall have the right to move freely throughout the territory of India. All citizens shall have the right to reside anywhere within the territory of India. And then all citizens shall have the right to carry on any business, carry on any avocation, carry on any trade anywhere within the territory of India. Now take the case of this article. This is the high class guarantee given to every citizen. 19(1). If you see Article 14, the state shall not deny to any person equality before law or equal protection of law within the territory of India. If you see Article 21, as I mentioned to you, no person's life or liberty, personal liberty, shall be deprived, no person's life and liberty shall be deprived of except in accordance with the procedure established by law. Now, when the Constitution has come into existence, a man called Gopalan, A.K. Gopalan, one of the communist leaders, he was propagating his principles, his ideals, his party's philosophy. He has spoken in one of the places in Tamil Nadu. He was arrested under the prevention of the detention law, 1950. So he questioned that act. It will be a very interesting, message. When the writ petition was filed in Supreme Court under Article 32 of the Constitution of India, the former Attorney General's father, K.K. Venugopal's father, Nambiar, only came from Chennai and he argued the case. First time, 1950. A.K. Gopalan's case. This is state of Madras. He said, see, the Preventive Detention Act 1950 is draconian one. Reason is, this law gives maximum power to to the police or to the government to arrest a person and keep a person inside the jail without trial. Is it possible? If you and I go there somewhere else and participate in some good function, we always speak, we are law abiding. But however, the policeman comes and arrests both of us, puts us behind the bar, no inquiry, no trial. When this was challenged, arguments were made by Mr. Nambia, father of K.K. Venugopal. He said, right, the fundamental right guaranteed under Article 19(1) has been completely violated because all citizens are entitled to move freely throughout the territory of India is violated because you are arresting a man without any inquiry. Therefore, the fundamental right cannot be touched, cannot be violated. Number one. Number two, he said, if you look at Article 21 of the Constitution of India, it says that no person's life and personal liberty shall be deprived of except in the procedure as per the procedure established by law. Now, there is no procedure. How you are going to conduct inquiry? No procedure is is mentioned. So therefore, this the preventive law, the detention law 1950 is completely violative of Article 21, Article 14, and Article 19. Court said the Constitution, it is a 6-judge bench. 6 honorable judges of this court sitting together, they applied the narrow theory of the procedure established by law. What did they say? They said that, see, the law is very clear. The principles of this procedure established law says that the content of the law may be unfair, but the practice is in a fair, reasonable, just, then it is okay, we do not have anything, and we will not be in a position to exercise the judicial power. I am just citing one small example. I am just going back to the discussion that has taken place between Mr. B.N. Rao and the Felix Frankfurter. See, you take the case of 1882 Indian Salt Act, before we got independence. 1882 Indian Salt Act was imposed by the Governor General and Council, Lord Mountbatten, in those days. The Act, if you see section 6AB, nowhere, nobody in India can manufacture the salt. Nobody can manufacture salt. Nobody can sell the salt anywhere without a license granted by the government. Salt is one of the basic necessities. See, today I can run a liquor shop. The government can run a liquor shop. We are not bothered. That is not basic necessities of life, without which we can live. But the salt is the basic necessity. Without eating the salt, you will die. You cannot make a food. Sodium is very, very important for your body to function. And then they said, nowhere in India you can manufacture any salt. Practice is followed. It has been legislated properly. But look at the content of the purpose of the Act. What is the purpose of the Act? You are monopolizing only on the hands of the government. Today you may sell it for 100 rupees. Tomorrow you can sell it for even 1000 rupees. And the day after you can close down also. Arbitrariness. Therefore Article 14 test, you cannot pass the test. If you apply, if you challenge the validity of the Indian Salt Act 1882, it will not stand up to the legal scrutiny even for a while before the court of law, either the High Court or Supreme Court. The reason is because the very, very basic necessities like milk. Milk, nobody can sell it. Only the government will sell it. Nobody else is allowed to sell it. Arbitrariness. Why? Because Article 19 of the Constitution of India says that all citizens shall have the right to carry on their business, trade, avocation, anywhere within the territory of India. I am entitled to manufacture my salt because in India we have the coastal area. Every coastal area is completely is occupied by people, and then the people living nearer to the coastal area, they make use of this sea water. They sink a borewell, take water, and then they cultivate that water, and then it is coming as a salt. They are selling it. Their livelihood is depending upon that. So therefore they say that if you apply Article 14, equality before law. And if you apply Article 21, no person shall be deprived of his life and personal liberty, because my life is depending upon this manufacturing salt, selling my salt. And then Article 19, every citizen is entitled to carry on his business. That is also violated if you apply. The validity of the Act, Indian Salt Act 1882, cannot stand up even for a single scrutiny. Reasonableness won't be there. Full of arbitrariness. And also take the case of what we call the Rowlatt Act, 1990. In the Rowlatt Act, the government can come and pick up anybody. They can barge into your house and then pick you up and put you in the jail. They will not inform where you are. That is the Rowlatt Act. That is what is happening in the detention law. You say that you are entitled to keep a person inside the jail without trial, without inquiry for a year. Absolutely is unheard of it. The reason is the court is unable to go ahead because you don't have the principle called the due process theory. You have only the practice, the procedure established by law has to be applied. And then what happened? This has taken place in the year 1951. After several years, in 1978, when Manera Gandhi's passport was snatched away, impounded. She was daughter-in-law of the Prime Minister, then Prime Minister. She came to this court, filed a writ petition directly under Article 32. She said, my personal life and liberty is completely taken away, violating Article 19(1), which says that all citizens are entitled to travel, move freely throughout the territory of India. Not only that, my right to travel abroad is also part of my life and personal liberty. That is the argument advanced. 7-judge bench judgment unanimously accepted it. They have overturned the judgment of this Honorable Court, that is the 7-judge bench judgment of this Honorable Court. A.K. Gopalan was reversed. They said it should be a good law. They said, very innovatively, they said that the due process of law is synonymous to the procedure established by law. They equated it. Why? If you look at it clearly, Article 19C, very, very interestingly and candidly they said, you must read the judgment, Manera Gandhi judgment. It says, see, if a law is made by the legislature, either by the parliament or the state legislature, the law has to pass 3 tests, Article 14, Article 19 and Article 21. That is called the golden triangle test. If that act is passing through all these 3 tests, golden triangle test, that is what is laid out in the Manera Gandhi's case, then the act is valid. If the act is failing in one of the tests, doesn't pass through the reasonableness under Article 14, or if it is not passing through Article 21, if it is taking away the life and personal liberty of anybody else, or if it is taking away your Article 19(1), right to practice, right to speech, right to carry on your business, takes away, then it has to fail. They said that the procedure established by law is synonymous to the due process of law. Therefore, when the procedure is going to be fair, reasonable and just, equally the content of the act also should be fair, reasonable and just. So ultimately they said, we will adopt only the due process theory. So nobody, now the dream of Dr. Ambedkar has been accepted. But at the same time, I must tell you, B.N. Rao, he was keeping something in his mind, that a social legislation might be made. That is also good for the nation. But therefore, these 2 great individuals have joined together, and then ultimately they have gifted the great document that is called the Constitution of India. When we say, when we appreciate, when we always revere the contributions made by Dr. Ambedkar on the ground, on the premise, on the footing that he is the father of Indian Constitution, equally as Dr. Ambedkar on 25th November 1950 has mentioned before the Parliament that the half of my credit must be given to Mr. B.N. Rao we must appreciate that, the good gesture. We'll appreciate P.N. Rao also. Sorry, thank you.
Thank you, Raja. So nicely explained. It's experiment, honestly. Every month, one Friday, we are going to choose one constituent assemblies person
Yeah,
and their
speaker.
contribution, speaker as a speaker. You are the first one on this P.N. Rao's this thing.
Thank you.
Graciously, you accepted my request and made a lot of work also. Yeah, extemporally explained everything. Thank you very much. Now I ask Mr. Rahul Sharma will give vote of thanks.
Seshu sir has given me this opportunity of extended the vote of thanks, and I'm deeply grateful for this privilege. On behalf of my respected seniors and esteemed colleagues, I thank Mr. Justice T.Raja, Senior Advocate, for delivering such a wonderful lecture. Sir, you took us on a journey of the making of the Constitution, and before that, how the things were. So it was very eloquent and lucid and very comprehensive, sir. And you talked about like the man of honor, Sir B.N. Rao, Benegal Narsingh Rao. So like the way that you explained how he in his draft article that were there, and the draft article 15 which was there in the Constitution Assembly, it was discussed like whether it should adopt due process or the procedure established by law. There were two groups, like Aladi Krishna Swami Iyer ji was for the procedure established by law, and K.M. Munshi ji was for due process. And like when the members of the Constituent Assembly, they were not sure to go for which option, then the most knowledgeable person there, and Dr. Babasaheb Bhimrao Ambedkar ji, he delivered his speech and made them understand like what the pros and cons of the adoption would be. And then the voting was called for, and that time the procedure established by law was adopted finally, and it became Article 21 of the Indian Constitution. And so then you took us like how in the A.K. Gopalan case, the Preventive Detention Act was there, and how the journey like started from the procedure established by law, but the A.K. Gopalan case was overruled in the Menka Gandhi passport case in 1978. And so this is like, you made it look so simple that it is very complicated subject, but you made it very simple, sir, for all of us, sir. And you spoke about like
Seshagiri has given only 40 minutes time only.
yes, his International Court of Justice, like he was a judge of the International Court of Justice. Sir, in one of my visits around 10 years back, I visited the Hague, the ICJ, and then I was aware that a man from India, Sir B.N. Rao, was also a judge at the ICJ. Sir, that time, I wish I had accompanied you. I would have gone with you, and I would have gotten to know like so much more. Sir, thank you so much for this eloquent lecture, sir. And like you started the lecture with the Abraham Lincoln speech, the Gettysburg speech of emancipation. Sir, your speech here today was just like that, sir. We are all spellbound and mesmerized. Sir, and thank you so much. I thank, on behalf of the organizer, I thank everyone for your attendance and participation and for making it a resounding success. Thank you.